On December 16, 2025, electrician Matthew Moreland was working at an unoccupied home in Jessup, Maryland that had been severely damaged by fire. As part of his contracted work, Mr. Moreland was rewiring the alarm system, and while testing it, he triggered the alarm. An officer with the Howard County Police Department responded, and the interaction that followed was captured on the officer's body camera.
Police South.
Hi, how you doing?
Hey, good. How are you?
Good. You're setting off alarms here.
I'm working.
All right. Do you have ID on you?
I do not.
You don't have any ID?
Not on me.
Anywhere here?
Yeah, it's here. What do you need my ID for? I'm
Because
working.
I don't know who you are.
Well, I don't know who you are. Listen.
Yeah, you do.
I'm working, my friend.
Okay, look, step back. Step back. Do you have any ID on you? Or in here? Anywhere?
I think it's in my van now.
Okay, all right. I understand you're working, but
I don't understand what you need my ID for. I'm working.
I have to
here.
identify
And I told
you.
him.
I don't know who you are. I don't know who lives here. You're not the owner, or you don't live here, do you? That's why I got to identify you. You're setting the alarms off.
Well, I'm here working.
Exactly.
I got a reason to be here.
I understand that.
And I don't know why you got to push me in here.
I didn't push you in there. I just backed you up because it's freezing cold outside.
Mr. Moreland confronts the officer about pushing him, and the officer claims that he had not pushed him, but had merely, quote-unquote, backed him up because it was cold outside. However, the body camera footage clearly shows that the officer made contact with Mr. Moreland's chest and pushed him inside, ordering him to, quote-unquote, step back. The Supreme Court held in the 1980 case of Payton v. New York that the Fourth Amendment draws a firm line at the entrance to the home, and that the threshold to the home may not reasonably be crossed without a warrant, absent exigent circumstance, such as when officers are responding to an emergency, are in hot pursuit of a fleeing felon, or are confronted with imminent destruction of evidence. Now here, the officer did not obtain a warrant before entering the home, and critically, the entry was not consensual, as he physically pushed Mr. Moreland back from the doorway to gain entry. Now, although the officer stated that he entered the home due to the cold, frigid weather generally does not constitute an exigent circumstance that authorizes officers to enter homes without a warrant. The most plausible argument for the constitutionality of the officer's entry into the home would be the exigent circumstances doctrine. But a triggered burglar alarm does not fit neatly into any of the recognized categories of exigency. While the Fourth Circuit Court of Appeals, whose decisions are controlling federal precedent in Maryland, determined in the 1984 case of United States v. Dart that a warrantless entry into a burglarized storage unit was constitutionally permissible where the doors had been visibly forced and officers had reason to believe that the perpetrators were still on the premises. In this situation, there were no visible signs of forced entry, and the individual who answered the door, Mr. Moreland, was cooperative and offered an immediate explanation for his presence. There was no indication of an ongoing violent crime, no person in visible distress, and no fleeing suspect. The Fourth Circuit addressed a similar situation in the 1992 case of United States v. Moss, determining that even where an officer reasonably suspected a break-in, the circumstances warranted no more than a look from the doorway, not an entry. By physically pushing Mr. Moreland back to force his way into the home, the officer went considerably further than that, and there is a persuasive case that he did so without exigent circumstances, in violation of the Fourth Amendment.
It's not that difficult, dude. Where are you going? Don't walk away from me. Don't walk away. Walk back out here. Nope, walk back out here. Come on.
Why are you touching me?
Because I don't know who you are. Come on, let's go. Do you have ID?
I don't. I'm going to call the people that I'm working
Listen, you don't have ID in your truck or anywhere?
I probably do have it in my truck.
Okay, do you understand where I'm coming from? I'm coming to
I'm
an
going to call
alarm.
the people that
You're
I'm
in
working
here.
for.
Okay.
All right.
Somebody on the phone doesn't mean that's who owns this place. Jeez. Not that difficult.
Hey, Paul. So I'm over here and they got the police out here because the alarm's gone off.
Say that again?
I said I'm over here and they've got the police here because the alarm has gone off. Can you get Mr. Coffee to come on over here and clear this situation up? Thank you. And that'd be the owner. He'll come.
Okay, what's so difficult about having an ID?
What are you going to ID me for?
Because I need to know who you are. You're in a house that's not yours, setting the alarm
I'm a
off.
contractor. I'm working for a general contractor.
Okay, that's great, but I need to make sure you're valid to be here. Do you understand that?
My ID doesn't serve any purpose for that.
Yes, it does.
What does it tell you?
It tells me who you are in case later on you weren't supposed to be here.
So I give you my ID, you're going to leave. Leave me alone, leave.
Not necessarily. Okay. You don't need to know how we conduct our business.
Let's just wait for the owner to get here.
Okay, we'll wait forever.
Yeah, probably. And I'll call this fine lady Tracy.
Stay here. Don't walk away.
I'm going to get her phone number right here.
Okay, that's fine. That's fine. But don't walk away from me.
When Mr. Moreland walks into another room of the home to make a phone call, the officer forcibly moves him back to the entryway area and later orders him not to walk away when he goes to make another phone call. Now, these actions almost certainly constituted a seizure under the Fourth Amendment, which permits an officer to briefly detain an individual for investigative purposes only where there is a reasonable, articulable suspicion that criminal activity is afoot. As we discussed earlier in this episode, the officer's entry into the home raises serious constitutional concerns of its own, and it is equally questionable whether he had the requisite reasonable suspicion to detain Mr. Moreland once inside. A triggered burglar alarm is, standing alone, the kind of ambiguous circumstance that can contribute to reasonable suspicion. It does not, however, establish by itself that the person encountered on the premises is the source of any criminal activity, particularly when that person does not flee, does not act evasively, and volunteers a reasonable explanation for their presence. Here, Mr. Moreland opened the door, identified himself as an electrician performing contracted work, and provided context consistent with his lawful presence at the property. The Fourth Circuit Court of Appeals held in the 2021 case of United States v. Drakeford that in determining reasonable suspicion, officers must consider the totality of the circumstances, and, in doing so, must not overlook facts that tend to dispel it. Accordingly, there is a reasonable argument that the officer lacked sufficient legal justification to detain Mr. Moreland, having focused on the alarm while disregarding the innocent explanation already in front of him. However, it should be noted that officers are under no legal obligation to accept a suspect's innocent explanation simply because one is offered. The Supreme Court held in the 2018 case of District of Columbia v. Westby that officers are not required to rule out an innocent explanation before acting, provided the totality of the circumstances, including the plausibility of that explanation, still supports a reasonable inference of criminal activity. Now, while the Westby case addressed probable cause for an arrest rather than the lower reasonable suspicion standard applicable to a Terry stop, its underlying logic applies here, and a court would consider whether a reasonable officer, weighing Mr. Moreland's explanation against everything else visible at the scene, could still have concluded that criminal activity was a meaningful possibility. This is a report from a data broker. It's only a few pages long, but just look at how much personal information it claims to have. Companies like these collect our information and sell it without our permission. And the fact that scammers, spammers, or stalkers can buy the same information is honestly disturbing. The more I looked through this report, the more I realized just how much information about us is out there without most people ever knowing it. That's why today's sponsor is Aura. Aura identifies the data brokers selling your information, automatically removes you from them, and keeps checking to make sure your information stays off. There are plenty of services that help remove your data, but none of them offer as many features as Aura for the same price. On top of removing your information, Aura also includes identity protection and credit monitoring, so instead of using separate services for everything, you can protect much more from one place. Another reason I like Aura is that it's a US-based company whose business is protecting your information, not monetizing it. Your personal information is encrypted, and Aura doesn't sell your personal information. Aura also delivers fraud alerts 650 times faster than competitors. If another service takes 10 minutes to alert you, Aura can warn you in under a second, before a criminal has even finished placing a fraudulent order. Your data is being sold right now while you're watching this video. I'm taking steps to protect my information, and I think it's worth doing the same. Aura will find the brokers selling it and remove you automatically. Go to aura.com/audittheaudit and try Aura free for 14 days. You can also scan the QR code on your screen, or click the link in the description, or the pinned comment below. Thanks again to Aura for sponsoring today's episode.
Are you the only one here?
I am.
All right.
Turn around on westbound 108, you go southbound. I located an accident.
Do you have warrants or something? Are you scared to
No,
identify
not
yourself?
at all. And I don't answer questions.
You don't answer questions. Well, guess what? You're going to go in handcuffs in a second.
It's gonna be southbound just under the bridge for 108.
Hey, is this Tracy? Hey, Tracy, it's Matthew with Technic Electric. How are you today?
I'm not with a
Yeah,
worker
see,
here,
I'm
but he's
having a
refusing to
wonderful
identify
time with
himself.
these
I'll do
folks over
10
here. I was just wondering if you guys could come on over here and clear this up for them. They don't, they're worried that I'm not supposed to be here, so. Okay. Well, he said that he's not gonna be able to do
I'll talk
anything
to him on
over
the
the
phone.
phone.
Would you like me to talk to him? Who is this?
This is, the guy's assistant. Her name is Tracy.
Hi, Tracy. I'm out with this worker who's refusing to identify himself.
Oh, I understand. Not a problem. Mr. Coffey, I have Mr. Coffey in the car. We're on our way to the house.
Okay, how far away are you?
We are just passing State Home on Silver Parkway, so we're approaching Oakland.
Okay, I appreciate it. We wouldn't have this issue if this guy would just identify himself, but he's refusing to.
Oh, Matthew? Oh, okay.
All right, thank you.
It's not a problem. We'll be right there. I thought Mr. Coffey said he let them know yesterday about the restoration that's going on in his home, but we'll be there as quickly as possible.
I appreciate it. Be careful.
Absolutely. Thank you.
Thank you.
Yeah.
Hey, sorry I missed your call. I was on the phone with Tracy. Yeah, I just gave her a call after I got off the phone with you, so make sure they were on their way over here. Well, look, I've got the cop here, man. He's being redundant, I just want to,
Redundant.
I just want,
I got your worker here who refuses to identify himself.
I don't have a constitutional need to.
A constitutional need to.
All right, Paul. Well, I'll give
What are
you
you,
a
a
call
sovereign
back
citizen?
once it's cleared up.
You're being audio visually recorded, by the way.
I get it. We'll sit down on that stair there if you
Yeah,
don't mind.
yep, go ahead. I just don't understand why this is so difficult.
It's not going to do anything for you. That's the problem.
You don't know how we operate, okay? And I'm not going to disclose that information of how we operate.
Well, I don't have a need to ID, so I'm not going to.
You do have a need to.
What's the...
Legally, you have a need to. You don't belong here. No, I shouldn't say that. I'm sorry.
Okay.
That's not how I mean it.
Okay.
You don't live here. This isn't your house. You set alarms off, and you're refusing to identify
Well, I was
yourself.
working on the alarm.
Tell me how that looks.
I'm working on the alarm.
You just said you're working on the house.
Yeah, well, I'm an electrician.
Okay,
I'm here doing electric work.
But do you understand what I'm saying? How do you think that looks to me when you're refusing to identify yourself? You're in a place where you're setting alarms off, and you don't live here.
I don't understand that. What's the need for me to identify myself? I am a contractor. Clearly, the house is
Because
under
the
construction.
homeowner's not here, so I
And
need
he's
to know who you
notified.
are.
Mr. Moreland argues that he has no constitutional obligation to identify himself. The Supreme Court held in the 2004 case of Heibel v. 6th Judicial District Court of Nevada that states may require a detainee to identify himself during a lawful Terry stop, but only where the stop itself is supported by reasonable suspicion. Unlike states that have enacted stop and identify statutes, Maryland imposes no general obligation on a detainee to provide identification to a law enforcement officer, and the sole statutory exception, found in Section 4-206 of the Maryland Criminal Law Code, applies only to individuals carrying a handgun. However, a refusal to identify could, in some circumstances, potentially support a charge of obstructing and hindering a law enforcement officer in the performance of his duty. Obstructing and hindering is a common law misdemeanor in Maryland, committed when an individual acts or fails to act in a way that obstructs or hinders an officer in the performance of a specific duty. Critically, the offense requires proof of actual obstruction, not merely uncooperative conduct. In the 2011 case of Titus v. State, the Court of Appeals of Maryland reversed an obstructing and hindering conviction arising from a traffic stop during which the defendant had provided a false name to the investigating officer. The court held that the evidence was insufficient to support a conviction because the state had failed to demonstrate how the defendant's conduct actually impacted the officer's investigation, and that the mere act of giving a false name, without more, did not satisfy the actual obstruction requirement. Here, Mr. Moreland had already told the officer that he was a contractor working on the home. The officer failed to articulate any investigative purpose that identification would serve, and the homeowner was available to confirm Mr. Moreland's account. Under these circumstances, there is a strong argument that the refusal did not meaningfully impact any identifiable duty that the officer was performing, and therefore did not constitute obstruction, even if a court were to conclude that the officer had the reasonable suspicion constitutionally required to demand identification, which, as we discussed earlier in this episode, is far from certain.
Notified the police
He
department.
is now. No, he hasn't notified the police department.
Yeah, they came yesterday.
Okay, yesterday. Today they didn't. And when the alarm company calls to get the code to clear it, they didn't did not answer and did not give the correct code.
Oh, I've got the code.
They didn't call you. They called the owner.
Oh, okay.
This is such a simple thing that I've handled 9,000 times, and you make it difficult.
I'm not trying to be difficult, sir.
But you are being difficult.
Well, I just don't understand what
You
me
don't
giving
have
you
to
my
understand.
ID. I mean, I understand that you don't think that I have to understand,
Well,
but my ID does nothing. It doesn't tell you he's a contractor. He's supposed to be.
It
there.
tells me who you are. So later on, if the homeowner comes on and say, "Hey, somebody was in here," blah blah blah,
Well,
I know who it was.
I've got the homeowner comment, so that way we just don't even have to worry about it.
Well, regardless of that, you asked the question. I'm explaining it to
I
you.
gotcha. I gotcha.
I won't ask you questions because you don't answer questions.
Other than this, how's your day going?
I don't answer questions.
Lord have mercy.
I'll play your stupid game.
Hey, Jamie, how are you?
How are you?
Good. How are you?
Yeah, Mr. Coffee will be.
All right. Mr. Coffee's the homeowner?
Yes.
Okay, thank you. Appreciate it. You guys got here pretty quick.
Huh?
You guys got here pretty quick.
Yeah, I was almost done over halfway. Hi, Mr. Matthew.
Hello.
You fixing your lights?
I was working.
Are you listening to a call?
What's that?
Are you listening to a call?
Am I listening to your call?
No, are you listening?
Oh, that's not mine.
Oh, okay.
You get an ear for when they're talking to you.
Yeah,
It's not mine. I'm sorry.
Just to give you a heads up, I'm just one of Mr. Coffee's caregivers. His house was damaged by solar panels,
Oh, wow. Okay.
so they had to basically take the top off the house. He had to move out
Holy cow.
until,
Yeah.
so this is what's all going. So Mr. Matthew is one of the electricians.
Okay.
And Mr. Paul called me. He's the project manager with Strongwall Construction.
Mm-hmm.
So, but anyway, Mr. Coffee's going to come in and you can
Okay.
verify everything. Are you guys hearing the alarm and we're not hearing it here?
Was I hearing the alarm?
Yeah.
Yeah, well, I was testing it,
Print 10.
and I opened a window, and I came in right away and
That's
pushed
right,
the
thanks.
code in, and went back to work. So it was wheel, wheel, wheel for like 10 seconds, and put the code in.
So we got
Yeah,
two
back to
alarms,
work.
one general alarm and then one window alarm.
Yeah, so that means that, and then they're calling the phone, which is, I don't know if it's
He's supposed to
Mr.
call
Coffee's
the
cell
alarm
phone.
company and tell them to not report it while I'm working in here.
Yeah.
And that's how you avoid
He
this whole
probably
process.
hasn't. He probably didn't.
I can go down and talk to him if that's
Okay,
easier.
if you don't mind,
No,
yeah.
no,
Thank you,
no.
officer.
You're welcome. Thank you.
Okay, so.
Good afternoon.
Good afternoon. How are you?
I'm fine.
Okay. You're the homeowner here?
Yes.
All right. Do you have identification on you by any chance? That shows this address?
Sure.
Oh, perfect. Thank you.
See, what the problem is, I told another policeman yesterday
Yeah.
that they are working on my house.
Right. You have to tell the alarm company that.
And the electrician in there,
Yeah. Thank you. I appreciate it. The problem is the electrician wouldn't give me any information. He wouldn't give me his name. Wouldn't give me anything. He said it's not his constitutional duty to give me his name. And he doesn't understand that he's setting an alarm off and he doesn't live in this house. Yes, I need to identify who you are. Well, he refused to. So that's why we're here.
yeah,
Thank you.
okay, no problem. But the thing about it is this, he got everything hooked up.
Yeah.
But after getting everything hooked up, it came over the board that one of my windows
Yeah.
was open in the basement.
Uh-huh.
He went down in the basement, and none of the windows are open, but one of them was broke.
Oh, okay. All right.
And when that go off, it don't set off the alarm in my house because it's not completely, connected together.
Right, right.
But what I'm gonna have him to do, just go on and turn it off.
Well, you can either turn it off, or if it goes off, do you have a cell phone? Do they call you?
Nobody called me.
Okay, yeah, the alarm companies should call you, and you can give them like a code,
Right.
and they cancel us. But they said they didn't say anything about calling anybody. So
Yeah, well, nobody hasn't called me.
right, Mr. Coffee, are you 91?
Yeah.
Looking at your date of birth. My dad was born in 38. He's 87. He lives in Arizona. Still kicking too.
Oh, yeah.
All right.
I'll
Well,
soon be 92. My next birthday's in April.
are you going for 100? Come on, you can do it.
If God willing.
I tell my dad that, hey, you're going to make it to 100. He's like, I hope not.
See, I tell you, it doesn't make any difference for me how long I live. If it's God's will, I'll go along with it.
I'm with you there. I agree.
Oh, yeah.
When it's your time, it's your time. It's not our decision.
That's right. That's right.
All right. Well, like I said, if you want to talk to your alarm company and have them make sure they call you if it goes off, or set it up with him while he's working for them to call him and he can give a code, then we won't have to come out here if it goes off.
Yeah. Well, as I say, I probably have him to just go on and turn the alarm off.
Gotcha.
If you just turn it off, you see, you won't have to worry about it.
Right. All right.
Because I got to get that window replaced anyway.
Yeah. Well, I got what I need, so I appreciate you all coming out here so quickly.
Problem.
All right. Well, have a good day, sir. Thank you.
After the homeowner confirmed that Mr. Moreland was in the home permissibly, the officer left without further incident. Mr. Moreland told me that he subsequently filed a complaint with the Howard County Police Department and that Internal Affairs determined that the officer had not engaged in any wrongdoing. He also told me that he's seeking legal counsel and that despite reaching out to several attorneys, he has yet to receive a response. Overall, the Howard County officer gets an F for entering a private home without a warrant or valid exigent circumstances, detaining Mr. Moreland based on questionable reasonable suspicion, and responding to Mr. Moreland's assertion of his rights with indignation rather than legal justification. The Fourth Amendment draws a firm line at the entrance to the home, and none of the recognized exigencies that would permit a warrantless entry were present here. The situation that the officer encountered upon arrival was not an act of emergency. Mr. Moreland answered the door, offered an immediate explanation for his presence, including evidence of his uniform, and displayed none of the indicators that courts have associated with ongoing criminal activity. The officer, nonetheless, physically pushed Mr. Moreland back from the entrance and crossed the threshold without consent or a warrant, and his claim that he did so because he was cold does not constitute a recognized basis for warrantless home entry under any applicable legal standard. The detention that followed is equally problematic. As discussed earlier, Mr. Moreland had already provided a facially plausible explanation for his presence before any detention occurred, and the officer was obligated to weigh that explanation as part of the totality of the circumstances rather than disregard it. The officer's assertion that obtaining Mr. Moreland's identification would confirm whether he was authorized to be in the home is puzzling, as a name alone would not have verified that authorization, and the homeowner was already en route to provide direct confirmation. When Mr. Moreland calmly attempted to assert his rights, the officer responded with frustration rather than with any articulable legal basis for his demands. This interaction highlights how the constitutional protections afforded to the home can be undermined in practice when officers cross that threshold without the legal authority to do so, and how internal accountability mechanisms do not always provide meaningful recourse when they are. Now, Mr. Moreland gets an A for calmly and consistently asserting his legal rights throughout the encounter, remaining physically compliant while verbally challenging the officer's conduct, and providing a clear and coherent explanation for his presence that was ultimately confirmed by the homeowner. From the outset, Mr. Moreland identified himself as an electrician performing work on the home, volunteering context that was directly relevant to dispelling any suspicion that the officer may have had. He did not flee, did not act evasively, and did not physically resist the officer's commands, even when those commands were constitutionally questionable. As discussed earlier, Maryland imposes no general obligation on a detainee to provide identification, and Mr. Moreland asserted his right not to identify clearly and repeatedly without becoming combative, which is precisely the kind of measured, informed response that allows a constitutional challenge to be preserved without escalating an already fraught encounter. When the officer physically moved him on multiple occasions, Mr. Moreland responded verbally rather than physically, a distinction that carries significant practical and legal weight. Physical resistance, even in response to a potentially unlawful detention, can expose an individual to additional criminal liability and dramatically increase the risk of harm. Mr. Moreland's decision decision to remain physically compliant while continuing to assert his rights verbally reflects sound judgment under pressure. I commend Mr. Moreland for navigating a legally complex and physically coercive encounter with the kind of composure and restraint that meaningfully preserved his ability to challenge the officer's conduct after the fact. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out Audit the Court if you're interested in exploring the legal nuance beyond the body cam.